Okay, Mr. Miller.
May it please the Court. I am Ross Miller, and along with my co-counsel, Bryce Evans, I represent the petitioners in this case, Bessie Ileana Garcia-Gonzalez and Kevin Stephen Soriano Garcia. Your Honors, petitioners respectfully request that this Court reverse the decision of the Board of Immigration Appeals denying their motion to reopen for two reasons. First, because the agency committed an abuse of discretion in finding that petitioners failed to establish that they were prejudiced by the deficient performances of their prior counsels. And second, because the agency also abused discretion in finding that petitioners failed to establish their prima facie eligibility for asylum, withholding of removal, and protection under the UN Convention Against Torture. Your Honors, the Supreme Court has long held that motions to reopen serve as an important safeguard against improper dispositions in immigration proceedings. This important safeguard is perhaps most relevant in the context of ineffective assistance of counsel before the immigration court, since many non-citizens lack English language proficiency.
Lozada is a high standard, but the BIA assumed it. So the question before us really is just prejudice, correct?
It essentially is, Your Honor. What standard to that prejudice requirement that the board applied? And our position, Your Honors, is that the agency abused discretion by applying an unduly burdensome prejudice standard to their reopening request. And Your Honors, we know this based on the agency's own precedent in the 1996 case matter of...
Well, before you get to its precedent, I thought the ruling was pretty limited, just saying that no evidence had been presented as to how a family is viewed in Honduras, whether it could qualify as a PSG.
Well, Your Honor, actually, the agency recognizes that petitioners may have established that their family-based social group was distinct within their community. However, in finding that they failed to establish prima facie eligibility for asylum and withholding of removal based on the cognizability of the social group, the agency concluded they didn't show that their group was socially distinct throughout all of Honduras. And, Your Honor, this is a holdover from the Attorney General's now vacated precedent in the 2019 case, matter of LEA. There, the Attorney General overturned the board's previous precedent in the 2017 case, LEA 1, where the agency recognized that a nuclear family-based social group may establish eligibility for asylum and withholding of removal.
Certainly there's confusion, LEA 1, LEA 2, circuits out there as to when a family can qualify. But no matter what the standard is, there's got to be some evidentiary showing, or are you saying every family per se is a PSG?
Certainly, Your Honor. We would argue that every nuclear family is a cognizable social group. It meets the definition required under a matter of MEVG in that it's an immutable social group. Individuals can't change or should not be required to change their nuclear family.
That just completely opens Pandora's box, as you know, because almost every person is going to be a member of some nuclear family. That's a chaotic standard.
Well, we would argue it's not, Your Honor, because there are other evidentiary requirements that an applicant must satisfy in order to obtain asylum and withholding.
But it would always get you to the nexus step.
I'm sorry?
It would always get you to nexus.
Certainly, Your Honor.
Okay, but has any circuit adopted that?
Your Honor, the Fourth Circuit in Hernandez-Avalos doesn't even conduct, it's a 2015 case, they don't even conduct the cognizability requirements of matter of MEVG as they relate to nuclear family-based social groups, because the Fourth Circuit says nuclear family is a prototypical example of a cognizable social group. And to answer your question specifically, Your Honor, even though every nuclear family-based social group would be cognizable under the Act, this is consistent with congressional intent. If you look at the eligibility requirements for asylum, race, persecution on account of an individual's race qualifies them potentially for asylum. Every individual has a race, but that doesn't mean that every single individual is eligible for asylum. Once again, you have to meet those eligibility requirements. And as far as the motion to reopen goes, Your Honors, we believe the agency abused discretion by requiring petitioners to show entitlement to the relief sought. And in doing so, they cited to this court's precedent in the 1994 case, INS versus Miranda-Lores.
We don't even have jurisdiction over the motion to reopen.
I'm sorry, Your Honor?
We don't even have jurisdiction over the refusal to reopen.
We believe that this court does, in accordance with the 2018 case Diaz versus Sessions, whereby this court has exercised jurisdiction over a Lozada-based motion to reopen, whereby the question of ineffective assistance and the question of prejudice is a mixed question of law and fact. So we believe this court certainly has jurisdiction. And, Your Honors, in finding petitioners failed to establish their prima facie eligibility, once again, the agency cited to this court's precedent in Miranda-Lores, but petitioners maintain that Miranda-Lores is factually distinguishable from their case, and that as a result, the agency shouldn't have relied on that decision. Specifically, in Miranda-Lores, the applicant was a lawful permanent resident of the United States, and he was convicted of a Controlled Substances Act violation. Miranda-Lores sought as relief from removal in front of the Immigration Court a waiver under Immigration and Nationality Act Section 212C, but Miranda-Lores never filed the waiver with the Immigration Court, and as a result, his relief application was deemed abandoned. On appeal to the agency, Miranda-Lores complained that the failure to file the waiver was the result of ineffective.
I still have questions about the PSG here. Tell me succinctly what your answer is to the BIA's finding that the petitioner failed, quote, to submit evidence in support of the motion to demonstrate that Honduran society recognizes members of her son's nuclear family as a distinct group.
We believe that's not supported by the evidence of record, Your Honor. The record shows on
If that's true, where in your brief did you make that argument?
the sufficiency of the evidence, Your Honor.
Yes.
I believe we cite to the I-589 on pages 189 to 201. That's the evidence that was submitted in support of the motion to reopen, demonstrating the following facts, Your Honors, that lead petitioner's son, Kevin, was threatened and harassed by criminal gang members in his country, and that other members of Kevin's school were actually murdered when they refused.
Right. That would be the persecution and harm, but that doesn't rebut the finding of the BIA that you didn't offer any evidence to show that Honduran society recognizes members of the nuclear family as a distinct group.
Well, Your Honors, we also believe that the I-589 demonstrates that lead petitioner herself knew police officers in Honduras.
Right. Maybe I'm not. Where is the evidence about Honduran society's view of the family as a nuclear group?
Well, we would submit that that evidence is in the I-589, Your Honor, and that the story that petitioner has provided demonstrates that their family is viewed as separate and distinct because they challenged the authority of a criminal group in their country that's known for their harsh responses to such challenges to their authority. We would also continue to rely on the Fourth Circuit's decision in Hernandez-Avalos, finding that, once again, a nuclear family-based social group is a prototypical example.
What country was that?
I'm sorry?
In Hernandez, is that Honduras?
Hernandez-Avalos, I believe that was El Salvador, Your
Okay,
Honor.
but see, that's what I'm struggling with. I don't think any circuit has said across the globe family is always a protected group because the nuclear family has that distinctiveness. When you're citing as to other countries, say Somalia, it really may be that the clan itself is the recognized structure. So it's my reading, in spite of the uncertainty as to LEA 1, LEA 2, is that no circuit has said what you're arguing, which is no matter what society you're in, a family, nuclear family, is always a recognized protected social group. That's what I'm struggling with.
We believe that the Fourth Circuit says exactly that in Hernandez-Avalos, that every nuclear family, it inherently is socially distinct. It's clear who's a member of the nuclear family and who's not a member of that nuclear family. It's an immutable characteristic, and that virtually every society organizes itself around the fundamental family unit. And so a nuclear family...
I mean, that's just an assertion you're making. But you know, again, I think you cited case law from Somalia where it is a tribal group, it's a clan. That really may not be true, that a nuclear family, mother with son, gangs trying to recruit, has any distinctive quality.
Well, we believe that every nuclear family-based social group has those distinct qualities. And that
the authority for that is the Fourth Circuit, El Salvador.
Yes, Your Honor. But moreover, Your Honors, we also believe that the agency abused discretion in finding that petitioners failed to establish it's more likely than not they will be tortured in their country, thus demonstrating that they failed to establish prima facie eligibility for protection under the Convention Against Torture. And this is so, Your Honors, because the evidence of record compels a contrary conclusion. The only evidence in the record demonstrates, once again, that lead petitioner's son challenged the authority of an ultra-violent criminal group, that others, individuals similarly situated to Kevin, who did the same exact thing, were harmed and even killed for conducting the same activities. And the evidence further shows that lead petitioner herself knows police officers in Honduras who have corrupt ties to gangs, and that her nephew even reported his victimization to the authorities in Honduras, and that the authorities subsequently informed the gang of his reporting and his attempt to obtain protection. So the only evidence in the record demonstrates it is more likely than not that petitioners will be subjected to harm and torture. The government hasn't submitted any type of evidence that contradicts that authority whatsoever, so we believe the agency abused discretion in reaching this conclusion. And Your Honors, I do want to get back to my first point briefly. In LOG, the agency concluded that where a non-citizen requests a reopening or remand, and the non-citizen previously did not have the opportunity to litigate the relief application on the merits, and where the non-citizen has clean hands, they're not responsible for the failure to litigate. Under those circumstances, the agency is supposed to review the remand or reopening request under the reasonably likely standard, whether it's reasonably likely that they're eligible for the relief sought in reopened or remanded proceedings. And again, we know the agency didn't apply that standard here. They applied the standard articulated by this court in Miranda-Lores, which requires demonstrating you are entitled to the relief sought. That's a higher burden of proof standard, and because the agency applied that standard, it abused discretion. Miranda-Lores is factually distinguishable, Your Honors. In Miranda-Lores, the non-citizen failed to ever demonstrate that he received ineffective assistance of counsel. The record in this case demonstrates that the agency itself noted twice on the record that petitioners may have received ineffective assistance from prior counsel. The immigration judge who deemed petitioners' relief applications abandoned noted that on page 177 of the record. And when petitioner's second attorney filed an agency appeal bordering on frivolous, arguing that the court never instructed petitioners about the need to comply with their biometrics requirement, the agency denied their appeal, and in doing so, the agency noted that petitioner's second counsel never filed a Lozada-based motion to remand their case. These facts, Your Honors, clearly distinguish petitioner's matter from that in INS versus Miranda-Lores, where again, the non-citizen never even attempted to demonstrate that he had received ineffective assistance of counsel by complying with matter of Lozada's procedural requirements. Instead, the agency should have applied this court's precedent or prejudice standard in the 2018 decision, Diaz versus Sessions, where the court recognized that a non-citizen can show prejudice if the non-citizen can show, absent counsel's unprofessional errors, it's reasonably likely the result of the proceedings would have been different. Your Honors, petitioners maintain that this court is actually already applying the LOG standard. Again, heightened standard for reopening for prejudice in instances where a non-citizen doesn't have clean hands. They're responsible in some way for the failure to litigate, or where the non-citizen has already had the opportunity to litigate the relief application on the merits. These are two different standards, Your Honors, and the government even acknowledges on page 15 of their brief that this court applies a different prejudice standard to different reopening requests. Now, the government says that demonstrating entitlement and demonstrating it's reasonably likely to obtain the relief, those are all the same standard, but Your Honors, petitioners maintain that that's not a reasonable interpretation of this court's case law. Again, this court is applying that standard from LOG, and they're requiring a heightened burden of proof in instances where the non-citizen hasn't demonstrated that they have clean hands. They're not responsible in some way for the failure to litigate. And because the agency did not apply its own precedent in LOG, petitioners respectfully contend that the board committed a reversible abuse of discretion. And as a result, we request that this court reverse the agency's decision and grant their motion to reopen so that they may finally have the opportunity to apply for relief before the immigration court. Your Honors, I respectfully reserve the rest of my time for rebuttal.
Yes, you've saved time. Thank you, Mr. Miller.
Thank you.
Ms. Phillips?
May it please the Court, Rebecca Hoffberg Phillips on behalf of the United States Attorney General. Your Honor, what this Court has to decide in this case simply relates to the prejudice component, as this Court has already sort of indicated with the questioning with my opposing counsel. All of the LASADA requirements, all of the argumentation about the ineffective assistance is not relevant. The Board assumed without deciding that LASADA was complied with and moved right to the prejudice. The problem is that petitioners...
Doesn't this court need to speak at some point fairly strongly about this question of whether any alien can claim a particularized social group simply by identifying his or her membership in a nuclear family, and if so, how broadly that extends? That's a pretty important threshold issue, especially in this circuit, isn't it?
Your Honor, you're absolutely right, and that's the key finding here regarding whether he demonstrated the prima facie eligibility. First of all, there was no mention of social group in the initial motion to reopen. I want to point that out. The initial motion to reopen didn't bother to address the merits whatsoever, much less a likelihood of success. What happens is in the reply brief, what you have here, after the DHS said, well, you can't meet your burden on the merits, petitioner comes back and says, well, wait a second, I could raise the particular social group based on the nuclear family of my son. This is raised for the first time in the reply. So naturally, when it's raised at that point, there isn't a ton of argumentation and evidence done as would have been required in a motion to reopen.
Are you claiming that that's waived or forfeited? Normally, we don't take up a new argument from the
Your Honor,
reply
the
brief.
board could have found it waived and forfeited. Theoretically, yes, the court could find that and the board could have found it. In this case, the board did go on to review the cognizability, whether they demonstrated the prima facie eligibility rather than saying they waived the prima facie eligibility. The board very well could have found a waiver in this case, and I was a little bit surprised that they didn't. But they went ahead and addressed it, so the government has addressed it as well. And the fact is that in prima facie eligibility in this court, it is not good enough to say my opposing counsel messed up. It may very well be good enough in the Fourth Circuit, and they love to rely on the Fourth Circuit. I'll get to that in a moment. The Fourth, the Ninth, maybe the First and the Seventh, they have other requirements both for social group and for prejudice. The standard in this court is clear. You have to show a likelihood of success on the merits. There has been a different phrasing of that. Your Honor, the government would submit that the Miranda-Lores case is the most similar to this case because it is also a biometrics abandonment
When you say the
case.
standard in this court is clear, and you're talking a little quickly, and you're suggesting that they may win in other circuits, are you talking about the standard for when a family qualifies as a particular social group?
I'll get to that in a minute.
No, get to it right now.
Oh, okay. In those courts,
What's the case you rely on that clearly sets our standard as to when a family group qualifies as a particular social group?
well, Your Honor, it's the very lack of a case, right? The very lack of
We haven't spoken to this issue.
You have not spoken to
What circuit would you say got it right, reads the statute correctly?
I would say none of the circuits that have done it so far have really understood it well. And the reason is that their precedent predates LEA 1. And not only that, but some of the precedent predates MEVG. So what you have is precedent in the First and Seventh Circuits that actually predates all of the particular social group.
So if you're saying we haven't and no circuit's done it correctly, what is the government's position?
The government's position is that LEA 1 controls, that LEA 1 says it's a case-by-case analysis, and that LEA 1 says that under the facts and circumstances and what was argued in LEA 1 that that was sufficient. So the proper argument to make in this court is to say, how does LEA 1 support the cognizability of a particular social group? That entire argument and evidence is missing from, of course, the motion and the reply to the motion. The reply to the motion acts as though it's a categorical rule. As Your Honor, he was saying the Fourth Circuit has said it's, he claims that it says that it's categorical.
The government would like us to say it isn't categorical.
Well, the board has said it's not categorical.
Okay.
And the board has said in LEA 1.
But it is case by case.
Case by case.
And the BIA's ruling here was that there was no evidence at all. So it would fail under any test.
That's right.
But do you want us to go further and actually say what the test is?
No, Your Honor, we don't. The only thing that the government is arguing in this case, because the only thing that matters in this case is prima facie eligibility for reopening and making out a prima facie case. You can't do that with no argument or evidence. You can't do that by relying on out-of-circuit
Fail under any
precedent.
test.
Under any test.
Except the per se one.
Except a per se one where all you have to do is say, I'm going to raise a nuclear family, and therefore it has to be cognizable. No court post-LEA 1 has come to that conclusion based on LEA 1. The courts that have come to that conclusion have relied on precedent that predates LEA 1, including the Fourth Circuit. And I know where he's getting this from. There's a case called Tomas Ramos, which has said that an asylum officer erred in concluding the group of the son's immediate family lacked social distinction. And the court there was saying that the nuclear family qualifies as a cognizable social group. What the Fourth Circuit keeps doing is going back to Crespin Valladares, which is actually a 2011 case. Long predates MEVG, long predates LEA 1. And so they're going back to their own prior precedent. And First and Seventh Circuit similarly, Ninth Circuit similarly, go back to precedent that doesn't rely on the current state of the BIA case law. Now, the government acknowledges that LEA 2 was vacated by LEA 3, and I can briefly explain that for a moment. What LEA 2 did was basically try to indicate that family is often not going to qualify socially. So not be socially distinct and therefore not qualify as a particular social group. Usually, if the Attorney General in that case said unlikely, right? That's no longer the government's position, that it's unlikely that it won't qualify. In fact, it seems it very well likely could in many cases. And in fact, in LEA 1, they did find that it qualified. LEA 3 simply vacated LEA 2, and now we're back to LEA 1. LEA 1 says case by case. It does not say categorical. It does not say per se. And so when you're making an argument in a reply brief that says we win because it undeniably—
Again, I'm just going to ask you to slow down.
I'm sorry.
We're back at LEA 1, and that is where the government and BIA say we will be, or we're waiting for more rulemaking?
So LEA 1, LEA 3 says it is appropriately decided ultimately by rulemaking. The rulemaking has not been established, and what this court has done in every case in the last 2 years that I've looked at is punt on the issue of cognizability and move right to nexus, because it's usually the very obvious way to dispose of a case. And every decision that I've looked at, unpublished and published in the last 2 years, I do not believe
We
this
don't
court—
have that opportunity here, though, because the BIA never reached nexus. So we have to decide.
That's right, Your Honor.
Okay.
That's right.
And you're telling us we ought to decide consistent with LEA 1.
That consistent also with this court's own prejudice requirements, that you have to make out a case, that you can't do it by relying on out-of-circuit precedent and per se rules that don't exist. That's all the government's asking for here. When you make an argument in a reply brief and you say, we could raise a nuclear—
What would be wrong in the government's view if we said, well, we think LEA 2 is right. We think the Attorney General there was correct.
Well, we would say, first of all, I mean, LEA 2 is not good law for the government's purpose. If this court were to decide contrary to LEA 1 or decide to follow LEA 2, I mean, that would be, of course, the court can decide that I mean, you wouldn't actually have to overrule, to find that the requirements here weren't met, you don't have to reach that question.
But let's say we do. Is that a flawed reach?
Yes, it would be flawed in this case to overreach on this because there was no evidence under any standard, whether it's LEA 1 or LEA 2, in terms of how you're looking at a family. It's just completely unnecessary here because LEA 2—
I guess I keep asking,
Yeah.
You keep saying it's unnecessary, but would it be wrong legally according to the statute?
It would be wrong to rely on a case that no longer exists, that was vacated. If you want to rely on the idea behind it in terms of what it takes to prove social distinction, I guess the idea that this court could essentially be— I mean, this court previously found in the Pena case that the board cites that its precedent was not inconsistent with LEA 2. That Pena Oseguera, I think, is the case that's actually cited in this board decision. And the court there, basically it never really decided the issue, but just said it wasn't inconsistent with it. So it wouldn't be inconsistent with this court's precedent to follow the guidelines of LEA 2 theoretically, but that's not the position the government would like the court to.
What if LEA 2 were the law? A petitioner would have to show what?
They would have to meet all the requirements just the same. It's just the difference in LEA 2 was that it
I
hinted.
thought it required you had to show that a particular family.
Yes.
Okay, so tell me this. What is it that you have to show under LEA 2? How would any family qualify? They'd have to be a family that the entire country is familiar with?
Yeah, or something like above the average family. But that's not the government's position. That is not what I would advocate this court follow. And so I don't necessarily want to get into what you would show under LEA 2 because we don't consider that standing law anymore. But if you were under LEA 2, what LEA 2 said was that it's above and beyond a normal family. That sort of along the lines of the point you were making about everybody's a part of a nuclear family, right? So everybody's a part of a particular social group. And I think in that LEA 2 decision, that was sort of the problem. They sort of took it a little too far according to LEA 3, because now you've sort of created this presumption against having any family social group qualify. It just kind of took it over the edge, I think, was the problem. It was one thing to say, well, we can't make an assumption that nuclear families qualify, but now let's assume they don't qualify. And I think that was where LEA 2 sort of maybe crossed a line that the administration, specifically the Attorney General, did not necessarily think should be the law, that we have some inclination that it's unlikely to qualify. Well, it could qualify. It may qualify. That's the government's position, and that's the position of LEA 1, and it is still the position of LEA 2. It's just LEA 2 indicates that it likely won't apply.
Now, would that be country by country? That is to say, could country A possibly not really recognize the family unit as particularly important, and country B would, and that therefore aliens from one to the other would be treated differently?
Potentially. I think you brought up the Somalia case. That may have been the Sixth Circuit's Al-Gorbani case. I want to say that a case along those lines that where it dealt with a specific kind of clan, very distinct family traits in those kinds of cases in certain countries. Absolutely, it's country by country.
Well, but I mean, excuse me, you're giving a very responsive answer, and I appreciate it. But I mean, could a particular country just say the family unit, the nuclear unit, is not really cognizable in this country? It's not something that we really particularly look at?
It could be that in a particular country it's not socially distinct in the way that would be enough. And when I say that, I mean the government admits that we don't exactly know what exactly is required from country conditions, because the board only decided within the context of LEA 1 that it did qualify. The board specifically sort of left it open that we're not going to sort of give this holistic approach of what you have to do every time. And as LEA 3 mentions, it's better left to rulemaking. And so I think that's part of why this court has avoided getting into the substance of any actual family group claim, because it's not usually the necessary part of the decision. You can move to nexus here. Again, not necessary to decide, not because you can move to nexus, but because you can say there was no evidence at all. And so it wouldn't meet any standard at all, regardless of how much would have been required from a particular country. So here we're dealing with Honduras. If you're talking about El Salvador, if you're talking about Mexico, maybe they're similar. They're not Honduras. They're not meeting your evidentiary burden under LEA 1 and MEVG and WGR and this court's precedent in Gonzalez-Velez, which has affirmed those PSG requirements and saying this is what you have to show a particular social group.
How long ago was LEA 3?
2021.
So we've been waiting for 2 years, and you're not particularly complimenting the circuit law. It sure would help if someone would state what this standard is.
I agree, Your Honor.
And yet you're saying we shouldn't in this case.
You shouldn't, because it doesn't matter what the standard is, because it couldn't have been met with no argument or evidence. So there's no reason to come up with anything in this case, especially there were so many other cases.
I've already asked this, but you can't point to any circuit that you think's done it right.
I take that back. Maybe, I'm trying to see if maybe there was maybe the 8th or 11th in terms of what they specifically said. Nobody has, I think, directly said, like, you know, in terms of LEA 1, what does LEA 1 mean? And we totally endorse that position behind it, because most of the precedent predates it and they're following court precedent from beforehand. And so we don't have, I think most courts have also done, apart from the courts that I've mentioned, following precedent that predates the case. They're following precedent that says nuclear family qualifies, that doesn't rely on current case law. And then other courts, and this court, have not decided the issue because they decided on other grounds, such as nexus. And so, and usually that's the better way to go when you have an obvious easy way out. And you would have had an easy way out in this case had the board decided the nexus issue, because they can argue Hernandez-Avalos all day long, and that's Fourth Circuit precedent that was specifically rejected by this court in Barrios-Bruno. And so this court has already said that that nexus line of reasoning is not going to be sufficient in this court. And I think that's the whole problem with this case from start to finish, is relying on out-of-circuit precedent and not recognizing what this court requires is detrimental to this claim, because it fundamentally sets you up to not address the merits of the case. In some courts, the courts believe that no matter what happens, if you miss your day in court, you should get to have your proceedings reopened, and it doesn't matter what you would have argued. And that is similar. That's the case. Maybe I know it's the case in the Ninth. I believe it's the case in the Fourth. It's like per se prejudice assumed and applied. It's similar to the particular social group thing. If you want to say that in other circuits that they assume that you've made a showing about nuclear family and you're relying on the out-of-circuit precedent, you're not engaging with this court's precedent. It's the same, I mean, they keep raising the same sua sponte reopening jurisdiction argument even after it's clear this court has rejected that as well. And so if you keep making arguments that don't reflect what this court has already said, you're fundamentally setting yourself up to not meet the requirements. And that's what happened here, both on the bigger level of the prima facie evidence, a standard for prejudice, and on the smaller micro level for the family particular social group social distinction finding. This court actually—
Well, you really can't blame them if they don't have anything in the Fifth Circuit to rely on. They do the best that they can. We've all written briefs in private practice where we have to do the best we can with authorities that aren't really binding.
Well, sure, but for example, Your Honor, it's not up to the government to make the arguments for them, and it's certainly not up to the BIA. But for example, if you had tried to try to come up with arguments that would make your group socially distinct by presenting evidence in your country, by comparing your case to the facts of LEA-1. Now, in LEA-1, there was a family store involved. It was also the father's immediate family as opposed to the son's immediate family, which would have been here. I believe a father might have had, the last name would have possibly followed the father as opposed to the son. You would have talked about the name. You would have talked about how the society views the family. I'm saying even without this court having ruled on the social distinction issue for nuclear families, arguments or some attempt at evidence or arguments could have been made about why under LEA-1 this group qualifies, and even though it doesn't automatically qualify, here's why it should qualify, and here's how we get there, connecting the dots between the facts presented and what we know about the state of the law. I mean, what you have here, if you look at this court's decision in Lopez, which is a 2020 published decision, in support of the claim for entitlement of relief, he only presented an affidavit containing 2 sentences addressing his eligibility for this form of relief. He doesn't provide any specific detailed facts that would demonstrate a clear probability of persecution by gang members. It's almost exactly the same here, because what you have, this affidavit, notice every time he was talking about what evidence in the record, he's pointing to the Form 589, which isn't an affidavit, it's not a country conditions report, it's statements in a Form I-589 that arguably the attorney wrote and typed up himself. That's not part of the affidavit. He had the applicant create an affidavit for herself.
Did that form speak to how Honduras looks at the distinctiveness of a family?
No, not at all. And not only that, but it didn't speak to the issue really for cat protection either, in terms of by briefly saying that there's corrupt or they're tied together. I mean, also that's not actually presenting evidence, and nothing in the affidavit that the petitioner presented in support of the motion to reopen. The affidavit spends 1 sentence on the merits of the claim saying, I fear going back to my country, and everything else is about the Losada procedural requirements. So we don't get the evidence from the affidavit here either. And And let's say we're being like super extra generous and we want to go back to the original affidavit that was submitted as part of the initial asylum claim before the immigration judge, back before the proceedings were deemed abandoned. Again, there, you don't have the distinction component being made. You have a lot of allegations about the gang coming after me. And then the most she says about police was that I was in a relationship with a police officer, and that's another reason why I might be targeted, which would actually cut against the police being involved with the gang and corrupt. So neither of the affidavits that were presented actually go toward what you would need to show. I do want to point out this case has an unpublished decision, Flores, 843 Fed APPX 635. Because Flores failed to offer any evidence that his immediate family is perceived as a distinct group within Mexican society, the BIA did not err in determining that his proposed social group was not cognizable. This court has already said exactly what the government is asking here.
Is that in your brief or?
I did not cite, I cited a different one that basically said that the counsel's arguments
What's the site again?
The site is 843, and it's FED APPX 635 from April 12th, 2021. It is exactly what, and that's why there's no need to go beyond this decision and exactly what the government has argued in terms of keeping it away from the actual cognizability of a family social group. I see that I am out of time. Unless the court has any further questions, the government will rest on its brief.
All right, thank you, Ms. Phillips. Mr. Evans, for rebuttal.
May it please the court. Your Honors, the government's assertions fail for two reasons. First, Miranda Loris being INS is distinguishable from the case at hand. And second, even if this court finds that Miranda Loris is controlling, the petitioners have sufficiently established prejudice because of the ineffective assistance of counsel they received. Your Honors, the government's cite to Miranda Loris to support their contention that in order for the petitioner's case to reopen, they must conclusively show entitlement to the relief sought. However, in Miranda Loris, the petitioner in that case sought a 212C waiver, and although his attorney failed to file such waiver, on appeal to the board, the petitioner never alleged why he was reasonably prevented from presenting his case. He also did not comply with the matter of Lozada requirements, and additionally, he failed to show that he was sufficiently prejudiced because of the failure to file such waiver. And although the court in this case applied the heightened entitlement standard, we believe that the court followed a similar approach to the one in matter of LOG, where they differentiated between motion to reopens, where the petitioner had a chance to fully litigate their case, and where the petitioners also did not have a chance to fully litigate their case. In doing so, the agency noted that in motion to reopens that are coupled with aggravating facts, they should apply the heightened entitlement standard. And in cases where there aren't aggravating facts, such as the case at hand, that they should apply the lower reasonably likelihood standard. Your Honors, in our case, the petitioners have sufficiently complied with the matter of Lozada requirements, and additionally, they have sufficiently showed that they have been prejudiced because of their prior attorney's failure to submit the biometric requirements. Additionally, we have set forth prima facie eligibility for asylum, withholding, removal, and protection under the Convention Against Torture. Notably, Your Honors, in response to the confrontation letter, the petitioner's prior counsel admitted that it was her fault for the failure to submit such biometric requirements, and additionally, on the record, the agency noted that the petitioners could have received an effective assistance of counsel because of the failure to file such an application. As such, Your Honors, we believe that the board committed an abuse of discretion by applying the heightened entitlement standard, and instead should have applied a lower reasonably likelihood standard as applied in Diaz v. Sessions. Which brings me to my next point, Your Honors. Even if this court does find that Miranda Loris is controlling, the petitioners have sufficiently established prima facie eligibility for asylum, withholding of removal, and protection under the Convention Against Torture. And although the board specifically noted or denied the motion to reopen because they noted that the particular social group, specifically the nuclear family member of the writer petitioner, Kevin Serrano, was not socially distinct throughout the entire country of Honduras, the agency also—
Evidence was presented as to that question.
Sorry, I didn't
The
hear you.
ruling was that no, you hadn't presented evidence as to that.
That's correct, Your Honors, but the agency also noted that the particular social group could have been socially distinct within the community of Honduras, which is why we believe that the board committed abuse of discretion, because the evidence of the record compels the conclusion that the lead petitioner was threatened with death because of her specific relationship to her son, and that the gang members sought to overcome her maternal authority because she stood up to the gangs. And additionally, people that were similarly situated to the writer petitioner in this case, who essentially stood up to the demands of the gangs, also were killed because of such bravery. As such, we do believe that the record of the evidence compels the conclusion that the particular social group is socially distinct. And additionally, Your Honors, the evidence of the record compels the conclusion that we've sufficiently established prima facie eligibility for protection under the Convention Against Torture, because...
Just with a few seconds left,
Yes.
would you agree with her characterization of the other circuit case law and its inapplicability here?
I would disagree, Your Honor, because I believe that as you've mentioned, as in matter of LEA 2, at one point you did have to prove that these particular social group had to be socially distinct throughout the entire country, almost to the extent of being very famous. But as in 2021, the Attorney General overturned LEA 2, and as such, this is exactly why we're asking for a remand, so that the petitioners are able to present their testimony. As an agency noted in a matter of LOG, testimony is crucial in order for us to establish our eligibility. As such, Your Honors, I see that my time's up. May I briefly conclude?
You may with one sentence, huh?
Sorry. The board committed abuse of discretion, and as such, we respectfully request that you remand the case for further proceedings. Thank you, Your Honors.
Thank you, Mr. Evans. The case is under submission, and the court will take a brief recess before hearing the final two cases.